I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
All right, folks, buckle up, because what we're about to witness might just be one of the most baffling court appearances of the year. We're dealing with a self-proclaimed sovereign citizen who, despite not even being able to read properly, decided he was ready to represent himself in court like some kind of legal expert. Now, here's the kicker. His entire defense hinges on the idea that the trial is unfair simply because he only had about an hour to study the law, while the prosecutor spent 7 years in law school. Yes, you heard that right. He genuinely believes that's a valid argument. It's like showing up to a chess tournament without knowing the rules and then blaming the grandmaster for being too prepared. This hearing quickly turns into a reality check, and not a gentle one. It's frustrating, it's outrageous, and honestly, it's kind of fascinating to see how far removed from reality some people are. It's the legal version of bringing a spoon to a sword fight. Get ready to shake your head and laugh a little, because this courtroom encounter is both hard to believe and impossible to ignore. Let's dive in and watch this unfold. And don't forget to drop your thoughts in the comments while we roll through the madness.
People of the state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
Honestly, I don't even know where to begin with this one. We're watching a man who clearly struggles just to read a basic sentence, now standing in front of a judge trying to present his own legal motions, as if he's some kind of constitutional expert. It's hard not to cringe. If we're being generous, his reading level might be somewhere around 6th grade. And that's us being kind. But here's where it really gets absurd. He's seriously upset that he wasn't given enough time to study the law. As in, he believes the court should just pause everything so he can somehow catch up with years of legal education. It's as if he expects the justice system to stop spinning until he feels ready. That's not how this works. At all. There used to be a time when, if you didn't know something, you asked for help or hired someone qualified. You didn't demand that professionals wait around while you tried to figure it out on the fly. The court already gave him 3 clear options: get a lawyer, use a public defender, or represent yourself if you're competent enough. But instead, his chosen option 4, wing it and hope for a miracle. At this rate, you've got to wonder what his next move is. Will he ask the judge to delay the case so he can apply to law school? Or maybe he's waiting for an invitation to join the Supreme Court. Let me know in the comments what you're thinking about this guy so far. And now, let's get back into this unbelievable hearing.
All right, go right ahead.
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution, if need to. It's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions, making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules. And
Is it just me, or is everyone silently bracing for the judge to cut him off with a polite but firm nice speech, motion denied? Because that's exactly where this circus is heading. The man stood there reading his motion like he was auditioning for a dramatic monologue contest, not making a serious legal argument in court. You can almost sense that the judge let him continue reading just for the sheer spectacle of it. It felt less like a hearing and more like a courtroom open mic night. And honestly, that's probably the only reason she didn't shut him down within the first 30 seconds, just letting it play out for the amusement of the room. But let's get real. Judges have every right to dismiss baseless motions on the spot, especially when they are wasting the court's time. In fact, under Rule 11 of the Federal Rules of Civil Procedure, courts are specifically allowed to issue penalties for filing groundless, frivolous motions. This case is practically a textbook example of why that rule exists. Still, he seems to believe that if he just talks long enough, maybe, just maybe, the judge will have some kind of epiphany, realize he's been wronged by the system, and throw the whole case out. Spoiler, that's not going to happen. Not today, not ever. Let's keep watching and see just how long he can drag this out before reality catches up.
Impartial trial, miscarriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do know the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he is rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end, the deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
At this point, you really have to wonder, is this guy pretending to be confused, or is he actually this out of touch? Personally, I'm leaning toward him faking it, because it's hard to believe someone facing real jail time could be this unaware of how the legal system works. This isn't a pop quiz where guessing might get you a passing grade. This is a courtroom, and the stakes are real. What's even more baffling is that he had access to a court-appointed attorney, completely free of charge. All he had to do was say yes. But instead, he chose to represent himself and clog up the court's time with documents that barely qualify as coherent, let alone valid legal arguments. And then he has the nerve to complain that he only had an hour to study the law? That's not how any of this works. It's like he thought this was some kind of open note exam, where you could skim through a few pages and walk in prepared. Sorry, but no. Watching him ramble through legal jargon reminds me of that one kid back in school who clearly didn't prepare his project, so he just improvised and hoped the teacher wouldn't notice. Spoiler alert, everyone noticed. And in court, that approach doesn't just fail. It backfires. So what do you think? Is this a clever act to stall? Or does he truly not understand what's happening? Drop your thoughts in the comments as we jump back into the courtroom chaos.
It states that, and there's a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay,
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And oh, you didn't want that either. So then we went through the hearings. And I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a what, 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
Bogus information. You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
Honestly, credit where it's due. This judge handled the situation with remarkable patience. She probably could have shut things down much earlier, but letting it play out gave us all a front row seat to one of the most bizarre self-representations we've seen in a while. And let's be real, it was hard not to laugh at how completely unprepared this guy was. You really have to ask yourself, what exactly was going through his head when he walked into court today? Did he seriously think he was going to talk his way out of this using a wrinkled, barely readable piece of paper he may have picked up off the jail floor? This is exactly why understanding your rights actually matters. Not to pull off imaginary legal tricks, but to avoid ending up in a courtroom looking completely lost and out of your depth. Despite how lenient the judge was toward the end, the bottom line is this: courts don't have time for games. If you've got a free attorney ready to help and you still choose to throw together a last-minute speech filled with legal myths, don't expect anyone in the courtroom to take it seriously. His motion wasn't just weak, it was one of the most misguided arguments I've seen in years. Honestly, this guy became a textbook example of what not to do in front of a judge. The courtroom isn't a game show where you get to make up the rules as you go. And while this hearing didn't go his way, and was never going to, at least it served as a lesson wrapped in some unexpected courtroom comedy. But now I'm curious, where would you rank this guy on the courtroom intelligence scale? Earlier I said maybe 6th grade, but after hearing that closing attempt, I might have to revise that down to 3rd. Let me know if you agree or if you've seen worse. If you enjoyed this breakdown, make sure to hit that like button and subscribe for more real courtroom moments like this one. I post new clips and commentary daily, so if there's a specific hearing you want covered, drop it in the comments and I'll check it out. Thanks so much for watching, and I'll see you next time. Take care, everyone.